2039-FH, People versus Ryan Patrick Hoover. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I ask the attorneys to place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the People.
Good morning, Your Honor. Fabiola Galguero on behalf of Mr. Hoover, who's present via Zoom.
All right, and Mr. Hoover is also present by Zoom. Ms. Galguero, where do we stand with this case today?
Your Honor, I just had an opportunity to speak to Ms. Arnold right before logging into Zoom. We've had some difficulties getting on each other's calendars in the last couple of weeks. We would like to request a short adjournment of 2 weeks, just a pre-trial in 2 weeks. And given that we're close to the point of either we resolve or we don't, Ms. Arnold and I also discussed, requesting that the court, beyond setting a pretrial in 2 weeks, also just set trial dates for the summer, so that should we not resolve, the case is not held up.
Judge, actually, I would first of all ask, does the court have trial dates available between now and the middle of August?
We do, yes. I think we're fairly well booked through May at this point. I don't know exactly what the June, July, and August look like, but I think we do have some availability. I guess depending upon what you think the length of the trial would be.
Yeah, I'm thinking 2 days. What I'd like to do is talk to the victims if we can't resolve the case. One of the victims is a college student in Florida, and I'd like to be able to find out when she goes back to school and check her schedule, the other victim's schedule, and Ms. Galguero's schedule, just to see what dates we wouldn't be available, and then try to set trial dates at the next pretrial if we don't resolve the case. I think if we pick trial dates now, there's a substantial chance, someone would have a vacation or it might interfere with something. So I think if we could know our blackout dates, that would probably be a better time to set trial dates.
And yeah, I don't think it will be an issue scheduling a 2-day trial date in the time frame that you are talking about. So 2 weeks from today would be April 16th. So we can adjourn to April 16th at 8:15.
That works for me, Your Honor.
Me too.
Ms. Arnold, would you be willing to do a stipulation in order for that adjournment?
We will.
Okay. Is there anything else that we need to address today?
I would just ask Ms. Galguero if I have her permission to sign her name to that stip and file it.
Absolutely.
Okay, so we'll see everyone back on April 16th at 8:15 a.m.
All right, thanks, Judge.
Thank you, Your Honor.
Thank you. Okay, Ms. Underwood, Mr. Bowker is here. Are you going to need to speak to him?
I don't believe that's necessary, Your Honor.
Okay, this is file 24-21719-FH, James Thomas Bowker, or People of the State of Michigan versus James Thomas Bowker. We are here today for a pretrial conference in this case. We're proceeding today by video conference. First, can I have the attorneys place their appearance on the record?
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Bowker this morning, Your Honor.
All right, and where do we stand with Mr. Bowker's case?
Your Honor, Mr. Bowker is continuing to make very good payments. We are almost getting to the point where we're prepared to do some sort of delay plea, but we would like another 60 to 90-day adjournment. We believe the payments that Mr. Bowker had made have been considerable, and we believe 60 to 90 days would be advisable in this matter. And I don't believe the Attorney General has any objection to that.
Is that correct, Ms. Brenner?
Your Honor, that's correct. He is paying well. This was also a show cause date though, so just so that the court can take care of that on their docket. The defendant had failed to appear the last couple of times. I'm not sure why, but we were having issues with him, even though he's paying well, joining us for our court dates. So we do need to address that as well.
Yeah, thank you for that reminder. So sir, you are James Thomas Bowker.
Yes, Your Honor.
Sir Bowker, did you receive a copy of the motion, affidavit, and order to show cause?
Yes, Your Honor.
That show cause alleges that you failed to appear for a pretrial conference on March 19th, 2025 at 8:15 a.m. The maximum possible penalty for contempt of court is up to 93 days in jail or up to $7,500 in fines. You do have the ability to be represented by an attorney regarding this, and obviously Ms. Underwood also already represents you on the underlying matter. Ms. Underwood, you know how Mr. Bowker would like to proceed with respect to...
Your Honor, I believe Mr. Bowker came in later that day, and the court told Mr. Bowker that if he showed up today on time, the court would consider dismissing that. I believe that's how I remember. Mr. Bowker did show up after that, Your Honor.
I recall that he showed up at about 9:30 for an 8:15 hearing. And so I will, if I said I considered it, I will consider it, but I'm not going to dismiss it right now because the history of the file indicates a difficulty with Mr. Bowker appearing for hearings. He had 2 failures to appear in district court. He didn't appear on January 15th. He had a late appearance on March 19th. In addition to that, I ordered fingerprints to be done back in October of 2024, and those have not been done. So there's a bit of an issue with compliance here, so I'm going to leave this. I'll enter a not guilty plea for him, but for the time being, I'm going to leave this in place because I think there needs to be a little extra motivation for Mr. Bowker to do the things that he's supposed to be doing in addition to making his payments.
Okay.
I will, based on the agreement of the parties, adjourn this for a period of time. So I'll adjourn this to go with July 9th at 8:15 a.m.
Thank you, Your Honor.
Thank you, Your Honor. And I'll be happy to do the stipulation with Ms. Brenner's permission.
Yes, Rhonda, thank you.
Okay. So Mr. Bowker, your next date is July 9th at 8:15 a.m.
Okay, thank you, Your Honor.
You can go ahead and log out. Ms. Underwood, you need to speak to Ms. McClenny Vidales.
I don't believe I do, Your Honor.
Okay. All right, this is file 25-22160-FH, People versus Bianca McClenny Vidales. We are here today for a pretrial hearing. In this case, we are proceeding today by video conference. First name of the attorney's place their appearance on the record.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda, you were for Ms. McClenny Vidales, Your Honor.
All right, Ian, Ms. Underwood, where do we stand with this case today?
I spoke with her yesterday, Your Honor. Ms. McClenny Vidales was bonded out, Your Honor, so she has paid that. However, the jail term that she had then, her job was lost. She is trying to find another job. This is our first pretrial. I've explained the importance of her getting employment. She has an interview today, Your Honor. I would ask for a short adjournment on this matter for Ms. Vidales, Ms. McClenny Vidales, to stabilize her employment. I've explained that she needs to start making payments to justify her bond, and she's aware of that, Your Honor. I would ask for an adjournment over 6 weeks, Your Honor. Maybe 8 weeks.
And Your Honor, that's fine with me. I told counsel I'm going to be going on leave starting next week. I'll be out about 6 weeks. So that's fine if we set it out longer than that so that I'll be back when we reconvene. Since the defendant did post the bond, I'm looking for her to start consistent payments so we can move forward with a plea agreement and plan. So I think that would put her in a good position if she can get that figured out by the time we come back.
Okay, why don't we adjourn it then to May 28th at 8:15?
Thank you, Your Honor.
May 29th, Your Honor.
28th.
28th.
I'm sorry.
May 28th, 2/8.
Thank you. And I will do the stipulation in order,
Thank
again,
you.
with Ms. Brenner's permission.
Yes, Rhonda, thank you.
Okay. So Ms. McClenny Vidales, you'll need to log back in next time on May 28th at 8:15 a.m. with all the same Zoom information that you used today.
Okay.
All right, so you can go ahead and log out then. Mr. Lyons, are you ready to proceed with Mr. Shears?
I am, Your Honor. Thank you.
Oh, I'm sorry, we still don't have Mr. Daly. Did you want to wait for Mr. Daly?
Well, just on the newer file, Your Honor, if I may, and this is problematic, and I have to offer my apology to the court and to sister counsel. The last month or so, I've had a string of personal issues, hospitalizations, a number of things have kept me away. This is probably my first whole week back in quite some time. So I've gotten behind on some things, like responding to Mr. Arnold's 404B notice and staying on them to complete our exam transcript for the newer file. So I've gotten behind. I'm going to ask to adjourn these things out. I did want to ask Mr. Daly if he had a transcript that would cut down my time. So my apologies to the court and to sister counsel.
Problem. We've had a lot of people who've been out for a long period of time. Judge, I'm a little confused. I show Mr. Lyons on both files, and I'm not sure who the court shows and if Mr. Daly's court appointed, because if he's court appointed, it's my understanding that he is getting out of all those files. So I'm not sure if Ms. Dumont would take over the case or what we would do if Mr. Daly's court appointed on that file.
Yeah, yes, he was court appointed on the newer file.
You can come up and sit down if you want, Mr. Shears. So on the newer file, the 25 file, there was a substitution of attorney filed in district court on December 10, 2024, where it appears, Mr. Lyons, you substituted in for the public defender's office.
Was that after the exam?
Uh,
And Your Honor, that just shows you how screwed up my head is.
I'm only laughing because that's not normally like Mr. Lyons.
No, I'm taken aback, Your Honor, and I think the court is actually right.
The exam looks like it took place on January 23rd of this year, so that would have been before the exam.
Now, that's just weirded me out because Mr. Daly was there doing the exam for the co-defendant.
Right. Mr. Daly represents Cabrina Burciaga.
Right. Okay.
So he's, yeah,
Judge, you kind of scared me there.
I believe.
Yeah, I am the attorney on both files, but Mr. Daly is the co-defendant attorney on the 25 files.
Okay.
Okay.
Yeah, he's the attorney on the co-defendant, Burciaga. So I think you're on both.
Yes. Yes, I'm on both for Mr. Shears. Yes.
Okay, good. That'll make it easy to set a pretrial date.
Boy, that really
All
had
right.
my heart going.
Okay. So how long of an adjournment were you looking for?
Your Honor, respectfully, if it's possible, since my guy and I be the co-defendant is out on bond, I'd ask to put this over possibly to the 30th of April, which is I think the last Wednesday of the month.
Okay. Any issue with that, Ms. Arnold?
No, that's fine, Judge.
Okay, so we'll go with April 30th at 8:15.
And I'll touch base with Brother Counsel going to see if he's still the one, if he's still handling the case.
Yeah, and
All right.
I mean, Mr. Lyons had said he was going to do a motion objecting to our 404B notice.
Right.
I could also do a motion in limine, but then we have his arguments and then I have to respond to his arguments. So I thought it was more efficient to have him just do a motion objecting and us do one response. But, you know, us doing a motion in limine is also an option. We just need to resolve the issue of whether evidence of what happened in one case is going to come in the other. And then we'll look at the consolidation issue so we can set the matter for trial.
And I'll get my objection to her 404B within the week.
Okay. Yeah, I don't care either way. Just wanted to offer that as an option.
All right. Okay, so April 30th will be our next pretrial date. Mr. Shears, if you want to come to court and attend in person, you're obviously welcome to do that. Or if you want to attend by Zoom, you can do that as well. Okay. Yeah, thanks. You're all set for today. Thank you.
Thank you, Counsel.
Mr. Lyons, would you do a stipulation in order for that adjournment?
I'll do that right now so I won't forget, Judge.
And you can
Okay,
sign my
thank
name.
Thank you.
Okay, Ms. Underwood, do you need to speak to Mr. Ballard?
I don't believe, well, just for a minute, Your Honor.
All right. Okay, the gentleman at Macomb County Jail, you're Mr. Stover?
Yes, Your Honor. Good morning. Thank you for having me.
Okay, 1 second. This is file 21-20605-FC, People versus John Mitchell Stover. We are here today for arraignment on several bench warrants, and we are proceeding today by video conference. Sir, you are John Mitchell Stover, correct?
Yes, Your Honor, I am.
Have you received copies of the request and warrant for probation violation in your file?
I do not have the copy of the paperwork. The only thing that I had been given was hold orders.
Okay. How long, Mr. Stover, are you going to be at the Macomb County Jail? Do you know?
Your Honor, with all due respect and no disrespect, I do believe this matter is going to be here. I'm going to be here at least for over a year.
Okay, I'm just trying to determine whether we can send copies of your warrants to you at the Macomb County Jail. So if you're going to be there for a while, we can mail them to you there.
Okay.
In the meantime, I will tell you that there are four warrants for alleged probation violations in your file here. The first is filed on February 28th, 2023. That warrant alleges that you violated the terms of your probation by assaulting your girlfriend, Crystal Fenderson, by pushing her with your chest, getting on top of her and choking her while biting her left cheek, then grabbing her cell phone, throwing it and breaking it so she could not call 911, then fleeing the scene, and your whereabouts were unknown. The second warrant is dated April 3rd, 2023, and that alleges that you violated the conditions of your probation by sexually assaulting your girlfriend, Crystal Fenderson, forcing anal sex on her while having your arm around her neck in a choking manner. The third warrant is dated July 28th, 2023, and it alleges that you violated the terms of your probation by assaulting your girlfriend, Crystal Fenderson, striking her with a closed fist to her left eye. The fourth warrant is dated July 28th, 2023, and alleges that you violated the terms of your probation by physically and sexually assaulting Crystal Fenderson, pulling her hair, biting her hand to keep her from defending herself, then using an extension cord attempting to choke her. He then got her ice to reduce the swelling in her head, and she suffered, and she refused, and he tried to force it on her. It also alleges that you sexually assaulted her on that date as well. You were, in this case, convicted of assault with intent to do great bodily harm less than murder. The maximum possible penalty for that offense is up to 10 years in prison. You do have the right to be represented by an attorney here today and at any other proceedings we have regarding this matter. If you're not able to afford an attorney, you can tell me that and I'll appoint one for you at public expense. Do you understand that?
Yes, Your Honor, I do.
Do you want to be represented by an attorney?
Yes, I do.
Do you have the ability to pay for your own attorney?
I do not at this time.
Okay. In just a moment, I'm going to deal with one other case first, and then I'll put you in a breakout session with someone from the public defender's office.
And Your Honor, if I could have the paperwork, please.
Yeah, in the meantime, we will send that to you.
If I may, Your Honor, is Miss Underwood going to be my attorney in this matter?
Yes, she is the person from the public defender's office that handles probation violations.
With all due respect, I'm going to recuse her now.
You don't have an option to recuse her. I can appoint the public defender's office if you've asked for your attorney, but you don't get to choose who your public defender is.
Well, there's just conflict of interest, Your Honor. I don't need biasness.
I'm not aware of any conflict. If there is a conflict of interest, then the public defender's office would appoint a special public defender for you, which I believe has happened with respect to the underlying case back when we originally went through this. So I don't know, Ms. Underwood, you might want to check into that if we're going to need to appoint a special public defender for him. I think that was previously a conflict of some kind.
Yes, it was, Your Honor. It was James Daly at that time.
What is the name of this individual, Your Honor?
It is John Mitchell Stover, Stover.
Thank you.
And Your Honor, if I may address bond at this time.
All right, let me work out the attorney issue because you requested to be represented by an attorney.
Your Honor, we had this case back in 2021. It's my understanding that Mr. Malero had the case and it was conflicted out. And Daly's, our last note is that on July 22nd, 2021, Mr. Daly took the case.
Okay.
If I may, Your Honor, back at that time, I did not have an attorney. It was pro se. I did not have one Sam Malaro, and the situation was, it was unconstitutional from the beginning because
Mr. Stover, Mr. Stover, please stop because we're getting into things that have no relevance to the current issues. You requested an attorney. Mr. Stover, don't interrupt me. You have requested an attorney. We're going to need to appoint someone, a special public defender, because there's a conflict in the public defender's office. We're not going to be able to do that today. So what I'm going to do is adjourn this until next week. I'm going to enter a not guilty plea for you on all of the allegations, and I'll adjourn this to next week. In the meantime, the public defender's office will go through the process of appointing a special public defender so that you can be represented at that time.
Yes, I understand that, Your Honor. I just want the record to reflect very clearly I was pro se, and you guys gave me an attorney unlawfully.
All right,
You guys,
that'll be all.
because at,
Mr. Stover, I'm
at-
not gonna argue. I'm not gonna argue with you today. The hearing is adjourned until next week, April 9th at 8:50.
I've asked you, Your Honor, to address bond.
What would you like to say about bond?
I'm asking for a nominal bond.
You have bonds on all of the cases, so you would be getting credit.
I don't, that's what I'm saying. I don't know of any of the bond amounts or anything. That's why it said it was for the amount of the actual case file, which was 1398 or 68 or something of that nature, I believe.
Okay, so on the July 28, 2023 warrant, you have no bond. On the on both of the July 28, 2023 warrants, you have no bond. On the April 3rd, 2023 warrant, you have no bond. On the February 28, 2023 warrant, you have a bond of $1,398 cash.
So just to reflect this clearly, you're saying that I'm getting credit for being here thus far. I've been locked up since February 1st, sir.
Correct. You'll be getting credit because you haven't posted bond on any of those warrants in this case.
Thank you.
All right, you can let them know that you're done with court for today.
Thank you very much. God bless you.
All right, Ms. Underwood, are you ready to proceed with Mr. Ballard?
Yes, Your Honor, thank you.
This is file 24-21953-FH People versus Joseph Wallace Ballard. We are here today for hearing on a warrant for failure to appear, as well as a summons for probation violation. We are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Ballard, Your Honor. Your
All right,
Honor,
and
Mr. Ballard has a probable cause scheduled tomorrow in district court for a number of felonies. I believe that we should put this matter out for 2 weeks, Your Honor, and see where those stand. At that time.
so I'll adjourn this then to April 16th at 8:15.
Thank you, Your Honor.
Thank you.
Mr. Ballard, you can let the officer with you know that you're done with court for today.
All done? Yeah. All right.
Are they here?
I think that's all I have in this court.
Okay, thank you, Ms. Allen. That's what she said. Kendall's not here. Okay, Ms. Dumont, you ready to proceed with Mr. Adams?
Yes, Your Honor.
This file 25-22140-FH People versus Richard Adams. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on record, beginning with Mr. Bayonet?
Alex Bayonetto for the people.
Katerina Dumont for Mr. Adams.
And Ms. Dumont, where do we stand with Mr. Adams' case today?
Your Honor, I received an offer from prosecution yesterday of as charged, no subs. At this time, we would like to set for jury trial in 7.
Okay, how many days do you think you'll need for a jury trial?
I would defer to prosecution.
Your Honor, I think we can resolve this in one day. The only thing I would ask is there is a co-defendant who is set for preliminary exam on Monday. I'd ask if the court would consider maybe putting this out to the end of May at least, or early June. If that case is bound over, I would be making a request to try both cases together. So perhaps if the court wants to get it on the books for 2 days just to be safe. But I'm not sure what's going to happen with the co-defendant on Monday.
And Your Honor, if we just do another pre-trial to wait to see what happens with that, that's fine as well. That makes it easier on court's docket.
Okay, why don't we adjourn this then to the 16th, April 16th at 8:15, and we'll see where that other case stands and what's going to happen in terms of consolidating or not cases.
Thank you.
Thank you.
Thank you, Your Honor.
Mr. Bayonet, would you be willing to do a stipulation in order for that adjournment?
I will, Your Honor. Ms. Dumont, can I sign that with your permission?
Yes. Yeah. Yes.
Okay. All right, thank you.
Thank you.
All right, and you have Mr. Tolmes here as well, is that correct?
Yes, Your Honor. I believe he's on Zoom.
Okay. Ms. Underwood, do you need to speak to Mr. Delaney?
I do not, Your Honor.
All right. Mr. Tolmes, are you there?
Yes.
This is file 25-22135-FH, People versus William Lee Tolmes. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on record, beginning with Mr. Bayonet.
Alex Bayonetto for the people.
Katerina Dumont for Mr. Tolmes.
I'm sorry, I did not hear that.
You want to try that once more, Ms. Dumont?
Can you hear me, Mr. Tolmes?
Yes, I can hear you.
I just said that I was representing you.
Thank you.
Yep.
All right, and where do we stand with Mr. Tolmes' case today?
Your Honor, we received an offer for him to plead to count 1, count 2 would be dismissed. I've advised my client of that offer. He said that he would not like any offer at this point and would like a jury trial scheduled.
All right, Mr. Bayonetto, how long do we need for a trial?
I think we can wrap this up in one day, Your Honor.
Okay.
Your Honor, I would ask for 2 just based on the witnesses I would subpoena.
Okay. Ms. Clark, could we have a 2-day jury trial date, please?
Tuesday, June 17th at 9 a.m. and Wednesday, June 18th at 10:30.
Works for the people, Your Honor.
That works.
Okay, so June 17th at 9. And the 18th at 10:30. All right, the court will then issue a scheduling order and send that out to everybody.
Thank you.
Thank you. Mr. Tolmes, you can, oh, I'm sorry, we need to set a final pretrial date, so let's use June 11th at 8:15, if that works.
Yes,
That works for the people, Your Honor. Thank you.
thank you.
Okay, so Mr. Tolmes, your next date is the final pretrial date on June 11th at 8:15. You can log back in on that date using all the same information that you used to log in today.
I appreciate that, Your Honor. Thank you.
Okay, so you can go ahead and log out.
Thank you.
Thank you.
Okay, Ryan.
Yes.
Okay, this is file 24-21828-FH People versus Ryan Robert Delaney. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brenner?
Good morning again, Your Honor. Sarah Brenner, Assistant Attorney General for the people.
Rhonda, I'll do it for Mr. Delaney this morning, Your Honor. Thank you.
Okay, and where do we stand with Mr. Delaney's case?
I've spoken with Ms. Brenner on this matter, Your Honor. This is another case where Mr. Delaney is making very good payments, and we're working towards some sort of a delay plea, but we believe another adjournment would be appropriate. That July 9th date, I think, would probably work very well on this case as well, Your Honor. And I would do the stipend adjournment with Ms. Brenner's permission.
And I don't have an objection to that, Your Honor, if the court wants to give Mr. Delaney more time. He's almost to the halfway point, so he's almost to the point where he could plead to an attempt with a delay. He's doing very well, so I don't have an objection to that, and I don't have an objection to Ms. Underwood doing the stip if the court grants that.
Okay, let's then go with the July 9th date at 8:15.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, thank you. Mr. Delaney, you're all set. You can go ahead and log out.
Okay, thank you.
Mr. Millar, we have Ms. Taylor here in person. You need to speak to her.
Thank you.
Yeah, sure.
Okay, Ms. Taylor, if you want to step outside, right outside the door, there's an iPad, and set you up in a breakout session with Mr. Millar.
Hey there.
Hey, Miss
Okay,
Taylor, can you hear
one
me?
second.
Did
1 second. Okay, Ms. Underwood, do you need to speak to Ms. Sager?
I'm sorry.
You need to speak to Ms. Sager?
No, I don't believe so, Your Honor. Well, yeah, just briefly, okay?
Okay. Ms. Sager, are you there?
Yes, I am.
Okay, I'm gonna put you in a breakout session with Ms. Underwood.
Okay.
Mr. Dagger Margosian, I don't, well, let me check one person. One person I don't recognize in the waiting, but otherwise I don't have Mr. Pluff here. Oh, he's here in person. Do you need to speak to Mr. Pluff?
No, Your Honor, thank you.
Okay. Mr. Pluff, you want to come forward to the podium? Are you Mr. Pluff? No. No. Who's? No, he's not here.
It's okay, Your Honor, I'll go to Judge Anselm's and I'll be back in a little bit.
Okay. Okay, Mr. Dillard, your attorney's working with another client right now. As soon as she's done, I'll have you, we'll get to your case.
Judge. Mr. Pluff is in the hall.
Okay, well, we just lost Mr. Dagger.
Okay, so.
Simmons.
Yeah, he was here. Mr. Simmons. Yeah, he asked for probation.
I have someone that just entered the Zoom meeting. Your camera's off. Your screen name is Tino U380AA. Can you tell me your name, please?
Sitting or standing, or does it make a difference?
If you could just stand at the podium, please. This is file 25-22103-FH, People versus Ruth Ann Taylor. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayer.
Alex Bayonetto for the people.
Salvatore Malero on behalf of Ruth Taylor.
All right, and Mr. Malero, where do we stand with Ms. Taylor's case today?
Your Honor, I'm asking to adjourn this. The basis of my request is Ms. Taylor has maintained regular contact with me. She met in my office last week. She showed me a video on her phone I think would help resolve the matter. But given the fact that her and I are advanced ages, we're trying to figure out how she can email that to me. She did email something to me, but it wasn't the video. Once I get that, I can share it with the prosecutor, and I think that will help resolve this matter. That's the basis for my request.
Mr. Bayonetto, anything to address from the people's side?
No, Your Honor. Thank you.
And I'm sorry, Mr. Malero, how long were you looking to go out?
Well, Ms. Taylor was able to email me. She just didn't attach the video, so probably maybe a month should work, I think.
Okay, let's go with May 7th at 8:15 then.
Judge, I don't think that date works. Why does that date work? Oh, yeah, that date does not work, Judge. I'm sorry.
Okay, you do May 14th.
That's fine. That'll work.
Okay, so May 14th at 8:15 a.m. Ms. Taylor will be your next date. Mr. Malero, would you do a stipulation in order for that adjournment?
I will, Your Honor.
Okay.
That was at the 14th or the 18th, Your Honor? 14th?
14th.
Okay.
Okay, so you're all set for today.
Okay, thank you.
And Mr. Malero, Ms. Hoover is here. Do you need to speak to her?
Judge, I thought this case was going to be re-dollied, I thought.
Yes, that's what I was gonna chime in with. The court should have the nollie on that already. I prepared that yesterday. I don't know if maybe it just hasn't reached the court yet, but it is the people's intention to dismiss it.
All right. If you submitted that yesterday, it's probably somewhere in the process. I may have signed it or may not have signed it yet, but that'll get done. So let's then just adjourn this without date on the assumption that that nollie is going to get filed here the next day or two.
Thank you, Judge. Thank you, Mr. Bayonetto, wherever you are.
Okay, so Ms. Bokor, you're all set. This case is in the process of being dismissed.
Okay, thank you so much.
Thank you.
Call me if you have questions, Heather.
Okay, thank you.
Do you want to get Mr. Pluff in the hallway?
Hi.
And Mr. Malero, Ms. Julia Iikenberg is here. Do you need to speak to her?
I do, Your Honor. I do need to speak with her.
Sorry. Okay. Are you Ms. Julia? If you want to step out to the hallway, there's an iPad out there, and I'll put you in a breakout session with Mr. Malero.
Okay, thank you.
Yeah.
Thank you, Judge.
Okay, this is file 25-221. Oh, I'm sorry, this is Justin. This This is file 25-22190-FH, People versus Justin Robert Pluff. We are here today for an arraignment in this case, and we are proceeding today partially in person and partially by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Baner.
Alex Bayonetter for the people.
Your Honor, Michael Dagger Margosian for Mr. Pluff.
All right, and Mr. Dagger Margosian, does Mr. Pluff wish to have the information read?
No, Your Honor.
And how does he wish to proceed today?
Your Honor, we've reached a resolution with the people. We're prepared to enter a plea. The court should have an amended information adding a count 2, and that's what Mr. Pluff will be pleading guilty to at this time. And there's a sentencing agreement for no upfront jail on that matter.
Okay, Mr. Bayonetter, is that a complete and accurate statement of the agreement?
It is, Your Honor.
Okay, Mr. Pluff, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Justin Robert Pluff?
Yes.
Mr. Pluff, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information, failing to comply with reporting duties of a sex offender?
That is correct.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court other than as we've discussed it on the record here today. Is that correct, Mr. Bandit?
That's correct, Your Honor.
Mr. Dagger Margosian?
Correct, Your Honor.
Is that also your understanding, Mr. Pluff?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove that you are guilty beyond reasonable doubt, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Pluff, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
And do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about June 1, 2024 through September 17, 2024 in Hudson Township, Lenawee County, Michigan, you did commit the offense of failure to comply with reporting duties of a sex offender?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Pluff to plead guilty?
No.
No.
Mr. Pluff, other than as we've talked about it on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
Mr. Dagger Margosian, do you want to establish a factual basis?
I can, Your Honor. Mr. Pluff, between the dates of June 1st, 2024 and September 17th, 2024, were you required to be in compliance with sex offense registry?
Yes.
And you were actually put on the registry in around approximately 2007.
That's correct.
All right. And one of the conditions of registry is that you are to keep your address up to date with the sheriff department.
Correct.
All right. And within that date, would you agree that in Hudson Township, County of Illinois, State of Michigan, that you had complied with the requirement of putting your own address on with the sheriff department? True? I didn't hear that. Is that true?
Yes.
Okay. And also, and what was the address that you were putting on the registration?
9375 Terrace View Court.
All right. And within that time frame that I listed, would you agree that there was a period of at least 3 days where you were not living at that address?
Yes.
All right. And you knew that you had an obligation to update or notify your registration, liaison about that change of address. True?
True.
All right. And you did not do that?
No.
Okay. I think I'm satisfied, Your Honor.
Mr. Van Adel, are you satisfied with factual basis?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Van Adel?
It has, Your Honor.
Mr. Dagger-Magosian?
Yes, Your Honor.
All right, I will accept the plea then. It has been given understandably, voluntarily, and accurately. Mr. Pluff has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've talked about on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for May 16th at 8:15 a.m. Mr. Pluff, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Okay.
And so if, Mr. Moore, you want to just step across the hall to probation?
Yes, yeah, if you could just step across the hall, it'd be great.
Okay. If you'll just step
Thank
across the hall to the probation department, they'll have a packet of information to give you in order to get prepared for your pre-sentence investigation.
Okay.
Okay, so you are all set for today.
Thank you.
Thank you, Mr. Dagger-Magosian. Mr. Goldstein, are you ready to proceed with Mr. Simmons?
Yes, Your Honor.
This is file 25-22121-FH, People versus Isaiah D'Angelo Simmons. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, I have the attorneys place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
David I. Goldstein, appearing on behalf of the defendant.
All right, and Mr. Simmons is present by video conference as well. Where do we stand with the case today, Mr. Goldstein?
Your Honor, I was recently retained in this matter, and I have been provided with the written discovery, but given the nature of the case, I suspect that there are videos, at least dash and probably body cams. And I did not receive those either. Well, I did not receive those from the public defender's office when they sent me the written discovery. So I'm asking if Mr. Bayonetto can provide that.
I'll put a note in the file and I'll make sure our office gets it to you.
Okay. Your Honor, I'm asking for an adjournment till the 30th of, the 30th of April.
Okay, so we will adjourn this then to April 30th at 8:15 a.m. Is there anything else we need to address with the case today?
Your Honor, Mr. Simmons just texted me a few minutes ago. I was not aware of this. Apparently, this case has been pending for a while. I'm looking at just a second, I'm trying to grab since May of last year, it looks like. And he has been, I don't know exactly when this case was filed, but the offense date is May of last year, I guess August, when it was charged. He has been testing since that time, and Mr. Coase can correct me if I'm wrong, but I'm not aware of any violations. So he's asking, I don't know how often he's testing, but he's asking if that can be either reduced or eliminated.
Judge, we have we actually have the contempt of court, in which he tested positive for cocaine back on February 3rd at the drug testing facility. Then he tested positive for cocaine for myself on February 10th. He was reduced to the color teal, which he only tests one time a week. I did get notification that he did miss on 3/27.
Yeah, they said it was they said the time that it dropped dirty, they said it was a fluke test. They had about 4 people that also dropped dirty for the same things, and they said that was on their behalf. So I wanted to talk to you about that as well.
Okay, I'm
About
sorry,
5
Mr. Coase, what you were saying?
Yeah, Judge. So he actually tested positive for myself and also the courthouse. So we did reduce it to one time a week, and then he was a no-show this last time. So, I mean, if he's having trouble with money, I mean, I could assist him as if he wants to test with me at the courthouse. I could lower the test to only $10 rather than what he's paying now, which is $20 over at the center. But I don't believe it should be eliminated. I mean, he was just testing positive for cocaine just a month and a half ago.
We can address that when we come back in April. I'll talk to Mr. Simmons about that.
Okay, I'm going to continue the requirement that he test, that can be with Mr. Coase at the courthouse rather than at the Lenawee County facility. But I do think that given the situation that continued testing is appropriate, so I'm going to leave that in place.
Thank you, Your Honor.
Isaiah, come and see me today. Stop over the clerk's office, let them know that you're here, and I'll come out and meet with you, and we'll figure out testing at the courthouse to save you some money.
Okay, thanks a lot.
All right.
All right, so April 30th at 8:15, Mr. Goldstein, would you do that stipulation in order for the adjournment?
I will. Mr. Bayonetto, can I sign your name? Is he gone?
David, is it possible that we can go back downstairs?
You
Yeah,
can.
we'll talk
I
about that
apologize.
with you. Yeah, okay. I want to get the videos, Isaiah.
Okay.
All right, you can go ahead and log out then, Mr. Simmons.
All right, thanks a lot. Have a good day, Your Honor.
Okay, Mr. Malero, are you ready to proceed with Ms. Julia Iikenberg?
I am, Your Honor.
You can come forward and stand at the podium, please. Mr. All right, this is file 25-22141-FH. People versus Melissa Eileen Juliet Iikenberg. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayanetto.
Alex Bayanetto for the people.
Salvatore Malero on behalf of Miss Juilliard.
Thanks.
Okay, Mr. Malero, where do we stand with this case today?
Yeah, I'm asking to adjourn the matter. The basis is that I'm trying to get this case in a position to be resolved, and I need additional time to do that.
Mr. Bayanetto, anything to address from the people's side? Mr. Bayanetto, are you there?
Yes, sir. I said no. I apologize if the mic didn't pick it
Oh,
up.
I'm sorry. Didn't hear you. Okay, so let's adjourn this then to May 14th at 8:15.
Thank you, Your Honor. I'll do the step in order.
Okay, thank you. All right, so your next date will be May 14th. May 14th at 8:15.
Okay.
You can come in person like you did today, or if you prefer to attend by video conference, you can do it by Zoom also.
Okay, thank you very much, Robert.
Bail has a Zoom info if you want that. Can you call the jail? Okay, the gentleman in jail room 4, are you Mr. May?
Yes, sir.
Mr. Malero, you need to speak to Mr. May.
Yeah, if I could, Judge, real quick. Shouldn't take long.
Yep. Oh, I thought. Yeah, that's fine. This is file 25-22194-FH People versus Matthew Ryan Ray. We are here today for a pretrial conference in the case.
How about the day of? I never saw that.
And we are proceeding, I'm sorry, we're here for an arraignment today, and we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Salvatore Malero on behalf of Matthew May.
And Surrender Matthew Ryan May.
Yes, Your Honor.
Mr. Malero, does Mr. May wish to have the information read today?
Your Honor, at this time, we would waive the reading of the information, waive any defects as a time and place of service of that information. We'd also acknowledge receipt of the witness list. Mr. May will stay in mute as to counts 1 and 2 and the habitual offender fourth notice in the information. He asks the court to enter a not guilty plea. Mr. May does have a charge that's scheduled for probable cause conference tomorrow. So I'd ask to adjourn this out perhaps 45 days as opposed to like 30.
Okay, so we can go with the May 14th date again. Be just shy of 45 days. So then a not guilty plea for Mr. May and set this for pretrial conference on May 14th at 8:15 a.m. Is there anything else that we need to address today?
I don't think so, Your Honor.
No, Your Honor. Thank you.
Mr. May, you can let the officer with you then know that you're done with court for today.
All right, thank you.
Yes. And Mr. Bice, I don't know if you're aware, you're always welcome to come to court and watch the proceedings if you want to. We also usually put them on YouTube. So if you wanted to watch that way and not have to come to the courthouse, you have that option. Right.
Prosecuting attorney, is that Isaac?
Can you hand me that phone? I think that it was. Let me just make sure. Yes, a different attorney handled it today because they each kind of stay in one court. But it looks like Mr. Sneed is the attorney that's actually handling the case making this.
That's right. Okay. So if I get a hold of him before I can actually talk to him on. Well, I would like.
Yeah, you can just contact the prosecutor's office and they'll put you in touch.
Okay.
Yep.
I think you should.
Okay, Mr. Malero, I think that's all that I had for you unless I missed somebody.
Well, I don't know, Judge. Well, can you hear me? There we go.
Yep.
So is Tessa Woolley moved to tomorrow?
Sam, she was.
Okay, and then I have there was a late addition, Judge Patrick Stevens for a VOP today.
Oh.
Which would break my heart. But
He is, let me call that. So this file 24-21943-FH, People versus Patrick Allen Stevens. We are here today for a hearing on a request and summons for probation violation. And we are proceeding today by video conference, and the courtroom is also open to the public. Mr. Malero, do you want to place your appearance on the record?
yes, Your Honor, Salvatore Malero on behalf of Patrick Stevens.
Okay, the record should reflect this was set for 8:15 a.m. Mr. Stevens is not present here in the courtroom today, nor is he logged into the Zoom session. The requested summons indicates that he failed to report or have contact with Delaney County Probation Department on March 18th or any time thereafter.
Yeah, Your Honor, if I may.
Yeah, go ahead.
So Mr. Stevens was in Veterans Court, I believe, and was over in, I think it's Battle Creek. I thought he was doing really well. I talked to Mr. Stevenson yesterday. Apparently, I don't know if there's a miscommunication. I don't know if he's still there. I did try the phone number that I have for him, but it said it was out of service. So I don't know if there's just some kind of miscommunication with him or if things went sideways for him.
Mr. Moore, have you had any communication with Jamie Wright from Veterans Affairs about Mr. Stevens? I seem to recall hearing something about him having another warrant somewhere or getting picked up on something else.
I could check into that, Your Honor. I just know Agent Stevenson advised me that he had a show cause hearing today. But so I can check into that.
All right. I think what I'd like to do is adjourn this a couple of weeks while we do that, because I'm fairly certain we had some conversation about that at the last Veterans Court meeting. And I think there's a good chance there's something else going on there. So let's adjourn this to April 16th at 8:15.
Thank you, Judge. I appreciate that.
And we should be having a Veterans Court meeting between now and then, so we can see what we can figure out of that as well.
Okay.
All right. Thank you, Judge.
Okay. All right.
Judge, if I may, that does not require my office to do the stipulation order.
Correct. We'll just do a notice for that.
Okay. Thank you.
Yeah. Okay. We have Ms. Underwood back now. Are you ready to proceed with Ms. Sager?
Yes, Your Honor.
Okay, and Mr. Murphy, I do have Mr. Dillon back here. Do you need a breakout with him?
I don't, Your Honor. Ready to proceed whenever the court's ready.
Okay. So this is file 25-22145-FH, People versus Julia Capri Lachey Sager. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys place their appearance on the record, beginning with Mr. Bayonetta.
Alex Bayonetta for the people.
Ron Underwood for Ms. Sager, Your Honor.
All right, yeah. Ms. Sager, are you there?
Yes, I'm here.
And you are Julia Capri Lachey Sager?
Yes, I am.
All right, Ms. Underwood, where do we stand with Ms. Sager's case?
Your Honor, Ms. Sager has entered into a plea agreement whereby Ms. Sager will plead to an added count 2 amended resisting and obstructing, and count 1 fleeing and eluding under the motor vehicle code will be dismissed. This is under a height of probation, Your Honor, Hoover to a height of probation, and I believe that, and the misdemeanors will also be dismissed, Your Honor.
Is that a complete and accurate statement of the plea agreement, Mr. Bayonetta?
Yes, Your Honor.
All right, Ms. Sager, would you raise your hand? Let me know when you have it raised, please.
It's raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
Ms. Sager, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information, assaulting, resisting, obstructing a police officer?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine?
Yes.
Are you satisfied with Ms. Underwood and the advice that she's given?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court, other than as we've discussed on the record here today. Is that correct, Mr. Banetto?
Correct, Your Honor.
It is, Your Honor.
Is that also your understanding, Ms. Sager?
Correct.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm explaining those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Sager, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted?
I understand.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
I understand.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, I do not.
Do you understand that you're giving them up?
Yes, I do.
How do you wish to plead then to the charge that on or about May 31st, 2024 in the city of Adrian, County of Lenawee, that you did commit the offense of assaulting, resisting, obstructing a police officer?
I plead guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises disclosed to court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Sager to plead guilty today?
No, Your Honor.
No, Your Honor.
Ms. Sager, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record today?
No.
Is it your own choice to plead guilty?
Yes.
Ms. Underwood, do you want to establish a factual basis?
Yes, thank you, Your Honor. Ms. Sager, on May 31st, 2024, were you in the city of Adrian, County of Lenawee, state of Michigan?
Yes, I was.
And at that time, did you come in contact with an officer, Jesus Rincon, a sheriff's deputy?
Yes.
And you knew he was a sheriff's deputy, correct?
Correct.
And did you assault, batter, wound, resist, obstruct, or oppose him?
Yes.
And he was performing his lawful duties, correct?
That's correct.
And what did you do? Did you run from him?
I ran from him.
You ran from him?
Correct.
And you knew he wanted you to stop, correct?
Correct.
You ran from him.
Yes, correct.
I believe the facts are sufficient, Your Honor.
Mr. Beto?
I'm satisfied, Your Honor.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Banetto?
It has, Your Honor.
Ms. Underwood?
It has, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Ms. Sager has had full knowledge of her rights and she's had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as it's been discussed on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for May 16th at 8:15 a.m. Ms. Sager, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Okay.
May I get a minute to speak with her?
Yeah, Ms. Sager, I'm going to put you in a breakout session with Mr. Moore from the probation department so that he can get some contact information from you.
Okay.
Your Honor, I'm sorry. Before we do that, can I just put one thing on the record? Ms. Sager, you reviewed a plea agreement in this matter, correct?
That's correct.
And I signed that with your permission, correct?
That's correct.
Thank you.
Okay. All right, so Ms. Underwood, you need to speak to Mr. Dillard.
Just for a second, Your Honor, thank you.
Your Honor, I see Mr. Conway is in a jail room now. Mr. Sneed did ask that he be present when that case is called. Can you just give me a heads up before you're going to call it so I can let him know when it's about to be called?
I was actually going to do it right now.
Oh, okay. If I could just let him know, I'll have him pop over.
Okay. Okay, Mr. Murphy, I think we can do Mr. Dillenbeck while we're waiting for Mr. So this is file 25-22197-FH People versus Ryan James Dillenbeck. We are here today for a pretrial conference in this case. I'm sorry, arraignment in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Matthew Murphy, appearing on behalf of Mr. Dillenbeck.
And sir, you are Ryan James Dillenbeck?
Yes, Your Honor.
And Mr. Murphy, does Mr. Dillenbeck wish to have the information read today?
No, Your Honor. At this time, we acknowledge receipt of the information, the witness list, and the discovery demand from the prosecution. Waive a reading of the information on the record. We ask the court to enter a not guilty plea and set this for a pretrial. I had tried to contact your office, the court, prior to today to try to see there's other files that Mr. Dillenbeck has that are set for pretrial on April 9th. I didn't think that setting this file with April 9th will be sufficient time to work with the prosecution to get a plea involving all three files. So I was wondering if we could address those two files today as well and set another pretrial on all three. Again, I know we could set a pretrial probably for the 9th, but I don't think we'll have any leeway. And so I just don't see a point in doing that ultimately, unless the prosecution has a different viewpoint.
Mr. Murphy, Mr. Bayonetto, any issue with just setting all three pretrials for the same date?
No, Your Honor.
Okay, let's go with May 7th at 8:15. And Mr. Murphy, if you just want to do a stipulation and order one for each file, we'll set them all for the same date.
And that would be on the older file. The one today, right, is an arraignment, so there's no stip needed for this one.
Yeah, so we would do the notice on this file because it's an arraignment, and then the two older files, if you would do the stipulation in order.
Yes, Your Honor. You said that was May 7th. You wanted that date?
Correct.
Okay. Thank you.
All right. Is there anything else we need to address with the file today?
I don't
No, Your Honor.
believe so, Your Honor, unless Mr. Dillonback, was there anything you wanted me to address that I haven't addressed?
No, thank you, sir.
We're all set then. Mr. Dillenbeck, your next date will be May 7th at 8:15.
All right, thank you, Your Honor. You have
Thank you, Your Honor. Mr. Dillonback, I'll be in touch with you, okay?
All right, thank you, Matt.
Yeah, take it easy.
You too. Have a good day.
Thank you. Thanks, everyone. Have a good day.
Thank you, Mr. Murphy.
Your Honor, Mr. Sneed and Mr. Dagger-Margosian are just finishing up a plea at Judge Anzalone's, so he'll be over in just a few minutes.
Okay.
Excuse me, Your Honor, I don't see my lawyer here.
He is here in the courtroom. You can probably see him just at the edge of the screen if you can see the courtroom screen.
All right, thank you.
I'm here, Mr. Conway.
Oh, okay.
Your Honor, did you already call Zachary Dillard case?
No, Rhonda is speaking to him right now.
Oh, all right, thank you.
Can I get a breakout room with Mr. Fry?
Mr. Fry, you can use the iPad outside, or if you want to log in on your own device, you can do that. Jump in.
So it would be just, what's that, is that height of plea, or is it gonna be height of sentencing?
It will be iPad sentence. This is file 24-21905-FH People versus Zachary Ryan Dillard. We are here today for a probation violation hearing. In this case, we are proceeding today by video conference. First, can you have Ms. Underwood place your appearance on the record?
Rhonda Underwood for Mr. Dillard this morning, Your Honor.
All right, and do you know how Mr. Dillard would like to proceed today?
Well, Your Honor, Mr. Dillard has a resisting and obstructing case down in district court that he just got, Your Honor. And he's on a PR bond on that. I don't want to delay this any longer than it needs to be delayed, Your Honor. But I also don't want to see Mr. Dillard incarcerated any longer than he needs to be either. So I guess I would like if anything, a very short adjournment just to see.
All right, I can adjourn to next week, April 9th at 8:15.
Thank you.
All right, Mr. Dillard, you can let the officer that's with you know that you are done with court for today.
All right, thank you.
Judge, on a separate note, I just found that Mr. Stevens, excuse me, is incarcerated in the Eaton County Jail right now.
Okay, in Eaton County.
Yes.
Mr. Fry, ready to proceed with Mr. Conway?
Yes, sir.
This is file 25-22102-FH People versus Ernest Lee Conway. We are here today for a pretrial conference in this case, and we are proceeding today by video conference, partially by video conference, partially in person. First, I have the attorneys place their appearance on record, beginning with Mr. Sneed.
Good morning, Your Honor. Isaac Sneed on behalf of the people.
Good morning, Your Honor. Brian Fry appearing for Ernest Conway.
All right, and where do we stand with Mr. Conway's case today, Mr. Fry?
Yes, Your Honor. This case is scheduled for jury trial next week. I think starting Thursday. We are prepared to proceed. The one thing that we would note is we did receive at the end of last week from the prosecutor's office some notices regarding using prior acts testimony at the trial. We would object to that being allowed and ask the court to order that that will not be allowed at the trial. That did not comply with the court's order, which gave a date that they had to be submitted to the defense, or the statute either, which requires 15 days notice of any such evidence. So we were not provided with sufficient notice for this type of evidence and aren't prepared to handle that at trial. Further, the other acts notice was deficient on its face, as it didn't give enough specificity of what other acts the prosecutor was trying to introduce, so we could try to mount a defense for those other acts. It was extremely vague and generalized about they were just planning to introduce other acts of prior domestic violence and left it at that, which, you know, is impossible for me to plan for or defend against. So, you know, it was too vague and didn't comply with the statutory time requirements. So we would ask the court to exclude that, Your Honor, from trial. Thank you.
Mr. Sneed?
Well, first, Your Honor, the statute provides 14 days notice, and the notice was provided to Mr. Fry 14 days in advance of trial. So I don't know how we're calculating dates these days, but in my experience, that complies with the statute. Next, with respect to the specificity, the court can review the notice, and the notice lays out not only the police report, but the page on the police report, and in quotations, the statements of the victim as to what occurred to her. So I don't know how it could be more specific. Next, the defendant has to state theory or theories of defense to assist the court in determining the admissibility of the 404B evidence. We haven't heard any theory or theories of the defense other than some general statement about specificity, where I think if the court reviews the notice filed by the people, it does lay out specifically the acts that witnesses will testify to regarding Mr. Conway's prior acts of domestic violence. Thank you.
So, Your Honor, Mr. Sneed is mistaken on the statute. The court can obviously look at the statute, but the statute says 15 days notice, as the same as this court's order. This court had issued a scheduling order that said that they had to be provided 15 days. So Mr. Sneed is mistaken on that fact, Your Honor. Further, Your Honor, when Mr. Sneed talked about the notice referring to police reports, that wasn't for prior acts evidence. That was him asking that the police officer be allowed to testify about statements that the alleged victim made. So that was a separate issue than the prior acts evidence that the prosecutor wishes to use at the trial, Your Honor. And again, the court can look at that notice. The notice says the alleged victim will testify about prior acts of domestic violence and leaves it at that. I have no police reports of these prior domestic violence, no dates, nothing about what happened. It's just completely vague in general with no way for me to prepare for that. Thank you.
Okay, the notice is not yet in the court's file, so obviously I'm at a deficit in trying to come to a decision on it. What I will do is take it under advisement and either issue a written order sometime before the trial starts, or address the issue at the beginning of the trial, or if we need to have some further hearing on it, to let you know. Yeah.
Your Honor, I have one other matter to bring before the court. I was notified last week that the arresting officer, Colin Castleberry, is going to be out of state on Thursday, April 10th, which is the first day of trial. In light of that and his unavailability, I'm asking the court to adjourn the trial for the shortest period of time, because otherwise we are prepared to proceed to trial.
Mr. Fry?
Your Honor, we would oppose that request. We're prepared to go to trial. My client asked for a speedy trial, I think back in January when this trial was scheduled by this court. There's been 3 months. We've had multiple hearings in between to bring this issue up, and now we're a week before trial, asking for an adjournment. This could have been handled plenty of times. We've been before the court on this hearing. There could have been a motion filed asking for adjournment. Instead, it's just brought up orally at the final pretrial a week before the trial starts. I mean, if I came before the court today and said, Mr. Conway is going on vacation next week, adjourn his trial, the court would not even think twice about denying that request. I don't see how at this stage of the case, where my client is sitting in jail, his freedom deprived, that the court would consider granting the adjournment that could have been handled months ago, plenty of time ago. This trial has been on the books. It's not like we just scheduled it. So I don't see a basis for adjourning it while my client sits in jail. If the court was going to adjourn this, I think the court has to release my client from jail on a PR bond due to the request from the prosecutor, but we would really ask the court to just deny that request. We're prepared to move forward.
Officer Castleberry is unavailable on the 10th.
That's correct, Your Honor. And I would leave it to the court's discretion regarding the bond reduction requested if the court is considering adjourning the trial. I do understand the trial is set for 2 days. However, I think with the 4 or 5 witnesses the people plan to present, there's a good chance we could get done in 1 day. And Mr. Castleberry was the arresting officer and will provide a substantial amount of testimony for the case. So that's my position, Judge. Thank you.
All right. Well, if we've got it set for a 2-day trial and he's available to testify on the 11th, then I would deny the request to adjourn the trial we can still accomplish what needs to be accomplished on the 10th and 11th. And obviously, Mr. Conway is incarcerated, and I think that the cost to him of adjourning the trial is greater than trying to perhaps rearrange some witnesses. So I would deny that request.
Thank you. And I have one more thing to bring to the court's attention, if I could, Your Honor. Regarding the timing, the rule of evidence 404B3C does provide notice in writing 14 days before trial for 404B evidence. The statute regarding domestic violence statements under 768.27 does require 15 days notice. And I admit that the 15 days notice for the 768.27 evidence hadn't been met, but that really is not the crux of the notice. Thank you.
All right. Okay, anything else for today?
No, thank you, Judge.
All right, Mr. Conway, you can let the officer with you know that you're done with the court for today.
All right, thank you,
Yeah. Ms. Underwood, we adjourned Patrick Stevens 2 weeks.
To the 18th? I'm sorry?
16th to the 16th.
To the 16th? Thank you.
Yeah.
I believe that's my docket with you then. Thank you.
Yeah, that's it. Thank you. Just. What's that? Yeah.
Your Honor, do we have any more potential pleas this morning?
The only person we have left is Terrence Tyndall, and he has not been here at any point this morning, so he's most likely just going to be a bench warrant.
Okay, I appreciate it. Thank you. I'm across the hall if there's an issue.
Okay.
Thank you.